You bought the house, you paid off the mortgage, signed the deed, your name is on the property record. In your mind, that piece of land is yours to use however you want. But what if I told you that a power company can walk into your backyard without asking your permission? That your neighbor might have the legal right to cross your property every single day? That you might never be able to build that pool or that garage, even though you own the property? This isn't theory. This happens to thousands of homeowners across the United States, and most of them only find out when it's already too late, when the project's already been bought, the contractor's already been hired, or worse, when the neighbor's already taken it to court. Today, I'm going to show you 3 types of easements that could be hiding on your property right now without you even knowing it. But first, don't forget to like this video and subscribe to the channel. In American real estate law, one thing surprises a lot of people. Owning a property doesn't mean having absolute control over it. It sounds contradictory, but that's exactly how it works in much of the United States. You can hold the deed, you can have paid off every cent of the mortgage, and still find out that someone else, a company, or even the local government, has a legal right to use part of your land for a specific purpose. This is called an easement. It's a right that allows someone who isn't the owner to use part of a property for a defined purpose. That right doesn't disappear when the property changes hands. It's attached to the land, not to the person. So when you buy a house, you're not just buying the walls and the roof. You're also buying any easement that was already recorded, even if nobody mentioned it during the showing or at closing. That's where the problem lies. A lot of people sign the purchase agreement thinking they're acquiring total freedom over that space. But the law separates 2 things that seem like the same thing: ownership and exclusive use. You can be the legitimate owner and still not have the right to fence off an area, build on it, or even stop someone else from walking through it. That distinction is subtle on paper, but it carries real weight once you start planning a renovation, a new construction, or simply want full privacy in your own backyard. And the reason this catches so many people off guard is simple. Easements aren't always obvious. Sometimes they're described in an old document, filed away at the county recorder's office, with no sign, no fence, no visual marker on the property at all. You could live in a house for years without realizing that a certain corner of your yard isn't technically yours to decide what to do with. There are 3 types of easements that come up most often in the United States, and every owner, buyer, or seller needs to understand them before signing anything. The first is the right-of-way easement, when someone has the legal right to cross your property to reach another location. The second is the utility easement, tied to power, water, sewer, and telecom companies, which may have guaranteed access to a strip of your land. And the third is the easement born from old situations, agreements, records, or long-standing uses that remain valid even after the property has changed hands several times. Let's start with the one that causes the most direct conflict between neighbors. The first easement you need to know about is the right-of-way easement. Imagine you buy a property, fence in the backyard, plan to install an electric gate at the side entrance, and suddenly discover that your neighbor has the legal right to walk through that exact area every single day. It's not trespassing, it's not abuse, it's a right recognized by law, called an easement of way. This type of easement usually comes up when a property has no direct access to the street, boxed in behind another lot. For the owner of that property to be able to come and go, by car or on foot, the law allows them a guaranteed right-of-way strip across the neighboring land. This right was normally created decades earlier when the lots were originally divided, and it was recorded alongside the deed of the property that needs that access. The problem is that when you buy the property carrying that obligation, you inherit that restriction right along with the walls and the roof. You may own every square foot of that land, but you can't close off, block, or prevent passage through that specific strip, even if the neighbor has lived there for 20 years and you just moved in. Putting up a fence, a locked gate, or even permanently parking a car in that area could count as a violation of the neighbor's right, opening the door to a lawsuit. And here's an important detail. This type of easement isn't always physically visible. There may be no fence, no sign, no dirt path marking the route. The only safe way to know whether your property carries this obligation is by checking the title, the property survey, and the public records at the county recorder's office before closing on any purchase. Real estate agents don't always mention this during a showing, often because they themselves don't dig deep enough to check, and that's exactly why buyers end up discovering this kind of restriction only after the money's already been spent, when it's too late to negotiate the price or reconsider the decision. The second easement that comes up frequently in the United States has nothing to do with neighbors. It involves power, water, sewer, and telecom companies, and it tends to catch owners off guard at the most exciting moment, when they decide to renovate. You plan to build a garage, expand the house, put in a pool, and discover that a specific part of your land is reserved by law for a utility company, even though it's technically part of your property. This is called a utility easement. It exists to guarantee that electric, gas, water, sewer, and telecom companies have legal access to underground lines, poles, pipes, and equipment running through your land, even though you're the official owner of that area. These companies need that access for maintenance, repairs, or replacements, and the law guarantees that right regardless of who owns the house. In practice, this means there's a strip of your land where you don't have full freedom to build. In many U.S. counties, putting up a permanent structure, a garage, a shed, or even a fixed fence over a utility easement can force you to tear it down later, sometimes by order of the utility company itself, sometimes by order of the city. And the worst part? It's usually the property owner who ends up paying for the demolition, even after paying to build it in the first place. What makes this type of easement especially treacherous is that it almost never shows up visibly in everyday life. There's no sign saying, "Don't build here." What exists is a line recorded in official documents, usually in the property survey or in the title recorded at the county recorder's office. If you don't ask to see those documents before buying or before starting a project, you risk investing thousands of dollars into something that will have to be undone. And there's another detail that catches a lot of people off guard. Even when a utility easement doesn't completely block use of that area, it can limit the type of construction allowed. A low fence, for example, might be fine. A heavier structure with a foundation, probably not. That's why, before any construction project, it's worth contacting the company responsible for the easement to confirm exactly what's allowed on that specific strip of your land. It's a simple phone call that can save you months of headaches and thousands of dollars wasted. The third easement is, by far, the hardest to spot, because it doesn't come from a recent contract or a visible utility line. It comes from the past, from agreements made decades ago, from old records, or even from continuous use of the land that, over time, turned into a legally recognized right in American courts. This type of easement can arise in several ways. Sometimes it was created when a large lot was subdivided into smaller ones, and the original owner guaranteed, in writing, some form of access or use for one of the parties. Sometimes it arises because someone used part of the land openly and continuously for many years, and that use, depending on the state, can turn into a legally recognized easement, even without any formal signed document between the parties. This is what many states call a prescriptive easement, and yes, it can be upheld in court even if the current owner never agreed to anything. What makes this easement dangerous is precisely its origin. Unlike the right-of-way easement or the utility easement, which typically show up in more recent organized documents, this third category can be buried in old records at the county recorder's office, in decades-old deeds, or in court proceedings the current buyer never even knew about. You can buy a house today, do everything by the book, and still inherit a restriction nobody mentioned, simply because it's buried in paperwork nobody bothered to dig up. And here's the part that worries real estate attorneys the most. This easement doesn't disappear with time, or when the property is sold. It stays attached to the property, passing from owner to owner, until someone takes formal legal action to modify or remove it, which isn't always simple or cheap. A neighbor can keep using part of your backyard exactly as they always have, going back decades, claiming exactly this kind of right, even if you just bought the house and never heard about any of it. That's why checking the property's full title history, not just the most recent document, makes such a difference before closing any deal. A good property survey, combined with a thorough title search, can reveal this kind of old easement before it becomes a real problem. The kind of problem that only shows up after the keys are already in your hand. After understanding these three types of easements, the question that really matters is, what does this actually change in practice? For current owners, for buyers, and for sellers. For current owners, an easement can limit decisions that seemed simple. That renovation you'd been planning for years, that fence that would finally solve the privacy issue, that home addition that would raise the property's value, all of it can run straight into a right that isn't within your control. And the problem isn't just what you can or can't build. An easement can also spark direct conflict with neighbors, utility companies, or even homeowners associations, especially when nobody has a clear picture of exactly where that right begins and ends. For someone buying a property, an easement can represent real financial risk. Imagine finding out after closing the deal that part of the backyard of your dreams can't hold the pool you'd already planned, or that the neighbor has a right-of-way running right through the area where you wanted to build an addition. That kind of late discovery can tank the value you had in mind for that property, and in some cases can even make the use you originally planned impossible. And for sellers, an undisclosed or unclearly communicated easement can turn into a serious legal problem. Depending on the state, there's an obligation to disclose certain known restrictions on the property before the sale. Hiding or simply ignoring that information can open the door to a lawsuit after the deal is already closed, with the buyer claiming they were misled into paying for something they didn't fully receive. That's exactly why checking the property's full title, hiring an updated property survey, and reviewing easement records at the county recorder's office before any negotiation makes such a big difference. That process, which can feel bureaucratic and slow, is exactly what separates a safe purchase from a problem that only shows up months later, when the money's already been spent and your options are far more limited. At the end of the day, owning a property in the United States isn't just about having the deed in your name, it's about understanding exactly what that deed guarantees and what it doesn't. And that's precisely the kind of detail, often buried in old paperwork, that separates the people who protect their investment from the people who find out, too late, that the land was never fully theirs. If this video helped you see something about your own property you'd never stop to think about, hit like "Aw." It helps this content reach more people who also need to know this before buying, selling, or renovating a property. And if you want to keep learning about your rights as an owner, tenant, or buyer in the United States, subscribe to the channel because every week I bring real cases and clear explanations like this one, straight to the point, no legal jargon.